Hello and welcome to Jurisage Academy's YouTube channel. In this video, we will be discussing important case laws of the Supreme Court for the month of April 2023. If you are new to our channel, we also have previously made videos for previous months as well, so you can check those out as well. So coming to April 2023 important cases, the first judgment is in the case of Veena Vadani Teachers Training Institute versus State of Madhya Pradesh. In this important two-judge bench decision, the issue was with respect to domicile reservation of 75% to B.Ed seats in Madhya Pradesh. So the Supreme Court has held that domicile reservation of 75% would amount to wholesale reservation, and wholesale reservation has been held to be unconstitutional in the case of Dr. Pradeep Jain versus Union of India. So that is why in this case the Supreme Court has directed the MP government to review the 75% domicile reservation in the B.Ed seats because that is unconstitutional and violates Article 14 of the Constitution of India. Now coming to the second important judgment for the month of April, we have the case of Arnab Rao Roy versus Consortium of National Law Universities. This could be a specifically important judgment for CLAT PG candidates because this judgment is relating to CLAT itself. So in this three-judge bench decision, the Supreme Court has passed some important guidelines, and this can be considered to be an important case for persons with disabilities because this has been passed under Right of Persons with Disability Act 2016. In this judgment, the Supreme Court has passed guidelines to ensure better accessibility for candidates with disability to appear in CLAT examination. While passing the guidelines, the Supreme Court has also made a reference to a landmark case of Vikash Kumar versus UPSC of 2021, in which the Supreme Court has interpreted some provisions of Rights of Persons with Disability Act in light of the UPSC examination. Now, before we move further, we do have courses on CLAT PG and all other LLM exams as well. If you're interested, you can check them out from the website or from the numbers given on your screen. Now, coming to the third important judgment, we have the case of in reference T.N. Godavarman versus Union of India. Now, as you know that T.N. Godavarman cases are judgments on environmental law. So in this three-judge bench decision, the Supreme Court has actually modified its previous order of June 3, 2022. So in this 2022 judgment, the Supreme Court has given directions mandating a 1 kilometer eco-sensitive zone around protected forests. So the Supreme Court has modified that order in this particular judgment. The Supreme Court has held that the area which is to be declared as eco-sensitive zone cannot be uniform and will be a protected area specific. So in some cases, it may be a 10 kilometer on one side and 500 meters on the other side. In certain cases, it may not be possible to have a uniform minimum area at all. So the Supreme Court has said that a detailed procedure is required to be followed as prescribed under Rule 5 of the 1986 rules. Now coming to the fourth important judgment for April, we have the case of Dr. Narendra Gupta versus Union of India. In this important two-judge bench decision, the Supreme Court was deciding on the issue of forced hysterectomies. So in this case, the Supreme Court has held that right to health is part of Article 21 of the Constitution of India, and the court has directed that all states and union territories must take stringent action for blacklisting hospitals once it is found that they have performed unnecessary or forced hysterectomy without the informed consent of the patient. Now moving to the next important judgment, we have the case of B.S. Hari Commandant versus Union of India. This is again a very important but a short judgment of a two-judge bench in which the Supreme Court has held that it is desirable that all courts and tribunals should number the paragraphs in their judgment. The court has also suggested adoption of a uniform format for judgments and orders, including paragraphing. Coming to the next important judgment for the month of April, we have the case of Sri Rakesh Raman versus Srimati Kavita. It's an important case on family law. So this two-judge bench decision has made some important and interesting findings with respect to irretrievable breakdown of marriage. So the court has said that since irretrievable breakdown of marriage is not recognized under the Hindu Marriage Act, it can still be read as cruelty under section 13(1)(1)(a) of the Hindu Marriage Act. The court has said that since it is still not a ground for dissolution of marriage, though a recommendation to that effect was made by the Supreme Court in the landmark case of Naveen Kohli versus Neelu Kohli. Coming to the last judgment for the month of April, we have the case of Pramod Singla versus Union of India and others. In this important two-judge bench decision, the Supreme Court has made some very important observations with respect to preventive detention laws. So the court has said that providing illegible documents to the détenu in preventive detention can cause prejudice, and this will violate Article 22, Clause 5 of the Constitution of India, where the detaining authority must explain the grounds of detention in a language understood by the détenu. The court has also made some very important observations and procedural safeguards in cases of preventive detention. The court has said that every procedural rigidity must be followed in entirety by the government, and every lapse in procedure must give rise to a benefit to the case of the détenu. So this is a very important case so far as preventive detention is concerned, and which makes it very important for CLAT PG. So this brings us to the end of our video and the important cases for the month of April. If you like this video, please like and share and subscribe to our YouTube channel.